This video is going to be about certain notable provisions of the contract. I've tried to highlight in here some of the provisions of the contract that people have asked about, provisions of the contract that I want to ensure that you are spending some time looking at and really taking some time in determining how those are going to be drafted. The first provisions in terms of the parties to the contract, the authority and the obligation. Remember that there are two parties to the contract. One is the authorizer, the other is the governance board. And when you talk about that, be sure you know specifically who the authorizer is and who the entity is that is going to be running the organization and is going to be entering into this contract. Make sure those names are correct. Make sure that those authorities are accurately described. The educational program of the school. One of the things that we talked about earlier is that charter schools have the ability to be very flexible in their educational models, in their curriculum, in the innovation that they use, in how they present material to students. Your charter contract, you want to make sure that you have a discussion of the educational program of the school, and particularly those instructional methods that you use, that a charter school uses, that are distinct from the general public school instructional methods. So if your charter school is a direct instruction charter school or a STEM school or an e-learning or a project-based learning, take some time to provide a description of that. And the reason why is that one of the things that you want to ensure is that that both parties have a full understanding that this is going to be the educational program and model that's going to be used at the school. So that if you are a charter school governance board, you want to ensure that the district is, or your authorizer, whoever that may be, is agreeing that this model will be implemented at your school. If you are a district or a different kind of authorizer, you want to be certain that the charter school governance board understands that they are receiving that you are authorizing a particular type of charter school. So you want to be very clear in that educational program of the school and that provision. You want to have in your contract, you want to delineate the authority of the governance board of the charter school. What authority does the governance board have to act? And when the federal grant came out, or when the federal grant was given to Wisconsin to really kind of expand and strengthen the charter schools in Wisconsin, one of the things that has been made very clear is charter school governance boards are to have autonomy in operating and running their school. And that's a really difficult piece of the relationship with an authorizer and a governance board, because the statutes in Wisconsin require an amount of oversight by the authorizer. And so it's hard, particularly when it's a district. And so it's hard when you start talking about the authority of the governance board. How much authority do they have? What are they allowed to do? This provision should reflect the principles and standards established by NACSA, which is the National Association of Charter School Authorizers. And this provision is required for schools that are receiving federal charter school program funds. So when you start to talk about this, I think my next slide puts in there, you talk about, do they have authority to set their own budgets? Do they have authority to review and hire or suggest or recommend their employees or their teachers? How does all of that work, and what authority do they have? There's a provision in the statute in 11840 that specifically states that, subject to the contract, which means that the contract can modify it a bit, that governance boards will have the powers necessary to carry out the terms of the contracts. And then those powers are listed right in the statute. You can see them in there. So when you are talking about whether you're the authorizer or you're the charter school, you're going to want to spend some time really determining what type of authority is your governance board going to have, and how much autonomy are they going to have, and how can you ensure that in your contract. The provisions of the contract with respect to employees. If you are an instrumentality charter school, the employees of the school are going to be district employees. But that doesn't mean that you may not, as a charter school governance board, want to have some input as to the hiring of those employees. If you are a Montessori school, for example, you may want to have some input in terms of ensuring that teachers that are hired for that charter school are teachers with Montessori training. However that works out, you're going to want to make sure to talk about that in the provisions of the charter contract with respect to employees. If you are a non-instrumentality charter school and the school board cannot employ your personnel, you're going to want to talk about just in terms of that your employees have DPI licenses and any provisions with respect to the hiring of those employees, and particularly background checks, licenses, things like that. One of the other provisions, and this is, sorry, I'm going to go quick back to this. In terms of employees of the charter school, you're going to want to consider whether to include in your contract. Are there a certain number of employees that you need to make your charter school successful and to run? What is that hiring process? Is there some collaboration between the authorizer and the governance board? How about evaluation and renewal of those employees? And then we talked about in terms of professional development. Is there a way to negotiate so that if you're a charter school governance board and you want to hire particular employees or make sure that those employees have training in a particular model of education, can you build that into the contract to ensure that they have those professional development days if you're an instrumentality of the district? Admission. Your charter school contract needs to talk about admission. How are students going to be admitted to the charter school? Both residents and students under open enrollment. If you're a district authorized charter school, if you are a charter school that is governed by one of the other authorizers, you're going to talk about are there particular grades that you serve and any admission requirements. Charter schools that are authorized by more than one school district. So in terms of charter schools where you have a consortium of charter schools come together to operate a charter school, you're going to talk about how do you fill that charter school and what students are admitted. Students from those districts and students that are open enrolled into the district where the school is located. So admission is one of the provisions that you're going to want to discuss. In this slide, you can see that these are some example provisions. Are there going to be enrollment limits? How are those set? Who sets them? When does the governance board set those limits? And what's the collaboration with the authorizer? Preferences. Under the statute, when you talk about students and admitting students into your charter school, the statute requires that you give preference to pupils and siblings of pupils who are attending the charter school. It says that you may give preference to children of your charter schools, founders, governing board members, and full-time employees, as long as the total amount of those students is no more than 10% of the charter school's total enrollment. So in your contract, you would want to address the preferences. The admission in terms of students with disabilities. If a student who has selected the charter school as a preference is a student with a disability, you want to ensure that you include a provision in there that talks about the fact that the IEP team for that student has to make the determination that that's an appropriate placement for that student. And then open enrollment. If you are a district authorized charter school, those district that is your authorizer will be setting space limits for open enrollment at their January board meeting. And then open enrollment applications that come in will be accepted and denied on the basis of those space determinations. So in your contract, you are going to want to talk about or at least address if you have students that are accepted for open enrollment in your district and check the box that they are requesting to be placed in the charter school. Can you have an agreement with the district, if you're a governance board, that the district will allow those students to be placed at the charter school? Because a district doesn't have to place a student any place that the student requests, any specific school in the district. The school district has the ability to place students where there is space available. So you want to make sure that you refine that a little bit in your contract. Administrative services. The contract should include a description of the administrative relationship between the parties. So is your district going to do all of the HR work? Well, they are if you're an instrumentality of the district. Are they going to be providing technology services? Will they provide lunch to the students? Will they be providing custodial services? Is that true even if your charter school is located off of the regular district campus? What will be provided to you and who will be responsible for those services? Special education, you're going to want to talk about the entity that's going to be providing special education. District authorized charter schools, the school district remains the local educational agency for purposes of special education, but in terms of the provision of services, will those services be provided at the charter school? Will a student go back to one of the other district schools for some of those services, how will that be handled? You want to make sure that you include that in your contract. Your funding. So in terms of how is your charter school going to be funded? It is really important, and I see this all the time, to make sure that the funding provisions of your charter contract aren't just taken out of the model contract and put into the charter contract if they don't reflect how your district is going to handle the funding provisions. So under the Wisconsin Charter School Law, if you are a district authorized charter school, the money that DPI pays in terms of per pupil aid will come into the district and be funneled through the district, and then the district will be providing the funding to the charter school. If you are a 2X or a 2R charter school, DPI provides that per pupil aid directly to the governance board. So if you're a district authorized charter school, is the district going to treat you like any other school in the district, and you submit a budget and you submit your expenses and the district pays those expenses? Or are you going to work it out such that the district says, we will pay the charter school a certain percentage of per pupil aid each year, and then the charter school has to budget and do the expenditures themselves? How is that going to work in your charter school? You're going to want to make sure your provisions accurately reflect what happens. If you are a 2R or a 2X, you're going to want to talk about whether or not and how much administrative fee goes back to your authorizer. So remember, if you're a 2R or 2X, you get the money directly from DPI. The statutes do allow your authorizer to charge an administrative fee for being an authorizer. You want to be clear in your contract what that administrative fee is. And if it's capped at a certain amount, how that's handled. The operational budget, in terms of a district authorized, make sure that you are providing in there, how is that budget established? Does it have to be approved? What is the approval process with the authorizer? What if you have an unforeseen cost as a charter school and you've put in your budget, how is that handled? Or if the district authorizer provides you a percentage of per pupil aid and you find that you need amounts above and beyond that as you're moving through the school year, how do you deal with that? So those issues should be discussed. Record retention policies. You have an obligation as a public school to maintain confidentiality of student records. You have an obligation to respond to public records requests. You have an obligation to retain student records for a certain period of time, and that depends upon what kind of record it is. How are you going to manage that obligation? Are those records going to be kept at the charter school? Are they going to be kept in the district? What does that look like? So you want to address that in your contract. Exemptions from policies. When you are a district authorized charter school, you need to indicate in that charter contract, are you going to be subject to the district policy, board policies? Are you going to be asking for exemptions from certain policies? Does the district authorizer require you to follow certain policies? Make sure that provision accurately reflects what you are going to do, and spend some time talking about that between both parties. Subcontracts, if you're going to be able to subcontract out as a governance board, say for example, you're going to hire all of your employees from CISA, you may want to have a provision in your contract that talks about that the governance board has the authority to enter into subcontracts for maybe it's employment, maybe it's other things, provision of educational services, those types of contracts. So you may want to have a provision in your contract that deals with that. Performance, you want to have provisions in your contract that deal with how are you going to evaluate the charter school if you're a district or an authorizer. How are you going to evaluate the charter school and determine whether or not that charter school is meeting applicable standards, state and federal standards, and whether that charter school should be renewed. So talk about that, or have a provision in your charter contract for how that performance evaluation is going to happen. You want a provision in your charter contract, and you want to spend some time looking at what would be considered a default of the contract, and when would both an authorizer and a governance board be able to revoke the contract and to get out of the contract without consequences. There, in that model contract, there are some pretty detailed revocation provisions that set forth the process by which parties can revoke the contract. So if you're not starting with the model contract, this is something you're going to want to look at the statute, the allowable provisions for revocation, and to be including those into your contract. The term of the contract, under Wisconsin law, a charter contract can be no longer than 5 years. It can be less, but it can't be more. So remember, that means it can't be 5 years and 2 weeks. It can't be 5 years and 2 days. It can be 5 years or less. So be sure that if you're in your term of your contract, you aren't stating the contract begins upon execution of the parties and ends on this date, because oftentimes the execution of the party and the ending date will be more than 5 years. So be clear about what that term is so it's not more than 5 years.